please. Thank you very much, ladies and gentlemen. All right, you may proceed.
Thank you, Your Honor. Please record.
That's right.
Ladies and gentlemen, I want to thank you for your time. I know there's been a lot of moving parts and a lot to do this week. I told you at the beginning of this trial that you had the important job. One of the things I wanted to tell you was why it's so important and why the judge told you that we have the best system in the world. It's because you decide. 12 people who are unrelated to anybody in the case, the parties, decide and are the backdrop of whether the state has proven their case beyond a reasonable doubt. Now, it's a good system and it's a strong system, but remember this, because sometimes I think we overlook this as well. What makes it a strong system is you 12 today. Because in courtrooms all around the country, right now, there are 12 people assembled in a jury box like you doing the same thing. What makes it strong is that you go by the law. Now, we don't always like the law. We don't always want to go by the law. But when the judge reads you the law of what it takes to convict a person in our great country, that is what you held up your hand to go by. If you do not, then the system we brag about is not there. If you do, it is there. And if you do, nobody can have a gripe with you, no matter what you decide, provided you analyze the evidence, not arguments, but the evidence, and apply that to the law. In a circumstantial evidence case, and the judge will charge you, Ms. Livesay touched upon it. The example I've heard before is that if you go outside and there's snow all over the ground, you're sleeping all night, okay? You didn't see it snow, but the snow wasn't there when you went to sleep, so it snowed. That's an example of circumstantial evidence. That is an example of believing a circumstance and another circumstance that leads you to a fact that you can believe. When Ms. Livesay tells you that you use circumstantial evidence in decisions every day throughout your life, there is a very distinct difference between that and what we're doing. Because this is a criminal case with severe consequences. Now, this case is about Heather Elvis, and it is a tragedy. But the trial today is about the fate of Sidney Moore. In our everyday lives, we do not use circumstantial evidence in making decisions where we stop and ask ourselves, do I believe that circumstance beyond a reasonable doubt, as that's defined by the law, and the judge will define it to you as, am I firmly convinced? So that's a big difference. The judge is going to charge you that in a circumstantial evidence case, you have to find each circumstance individually, by itself, beyond a reasonable doubt. In other words, be firmly convinced of each circumstance you rely upon. Now, why do we have these burdens? Well, we have these burdens so people who look suspicious but didn't commit a crime don't go off to prison and lose everything they got in their family and their life. That's why. But we also have that in circumstantial evidence cases because it's circumstantial evidence. Now, the solicitor twisted it a little bit, and I appreciate the argument that what we got is better than eyewitnesses and better than that. We don't have any direct evidence. That's why we have a strictly circumstantial case. So it makes sense to say that, but any prosecutor, anywhere, in any case, wants to have direct evidence. They want to have eyewitnesses, confessions, forensic evidence, fingerprints, DNA. They don't want to be left with a strictly circumstantial case because it's hard to convict on that. And the reason it's hard is because there is a fine line between circumstantial evidence and looking suspicious. Now, Ms. Livesay pointed out a lot of the questions I asked and names that I brought up. I brought those up for a very specific purpose. One, because the only thing I know is that Sidney Moore did not kidnap Heather Elvis. I do not know what happened. I cannot prove he didn't kidnap Heather Elvis. And I cannot prove that somebody else did not do something, because you can't prove a negative. Therefore, it's on the state to prove every circumstance beyond a reasonable doubt. The reason I asked the questions I asked was to demonstrate to you the ease with which suspicion and unfortunate circumstances can make you look bad or point the direction at you. They spent 2.5 years building every circumstance they could find against Sidney. Not looking for Heather, not investigating other possible suspects, which was not done. When I began working on this case, and I learned of Jeremy, and it took me the whole trial until I got around to who Jeremy was, and I know you probably were wondering the whole time, who's he talking about? Well, because the first 3 girls said, well, yeah, but I don't know. I didn't know he was abusive. Jeremy, she hadn't been around him since January 2013. It took me to the last witness in this case, Bree Warman, to admit and tell you that she lived with Jeremy in December of 2013. The same guy she says Heather Elvis bashed in her face and broke her nose. That's who she was living with. Heather Elvis is not here. Where is Heather Elvis? Where is Jeremy Fleming? I didn't ask those questions to throw you off. I asked those questions to make this point. Had law enforcement done their job fairly and appropriately, they would have investigated these people. But that's not what happened. And I told you at the beginning of the trial what happened was that they had a lot of pressure to do something. Because this case, unlike other cases, immediately garnered big-time media coverage. Immediately. And within a day, Sidney Moore's name was out there. Because Heather Elvis's father called him. She had heard that he dated him. And to his credit, I would do the same thing. I would. But then the social media starts. And the names Sidney Moore and Tammy Moore are all over the place. And you got the they did it, you got the they didn't do it. And it's all just taken on a life of its own. And man, is the Horry County Police Department getting heat, big time. So, 2 months into the investigation, only 2 months, they make an arrest. They arrest Sidney Moore and his wife Tammy Moore, and we're here today on kidnapping. They then give the file to the prosecutor's office. They're off the hook. We solve the crime, you prosecute the crime. Well, what happens? The solicitor's office has to spend the next 2.5 years trying to build a case against Sidney Moore. Where's the inherent danger in that? The inherent danger in that is that you are focused on one person to the exclusion of anybody else. The other inherent danger in that is you have to find stuff on this guy. You have to make it look bad. You have to make him look bad. This is a guy we've told everybody in the world that did this, or the police did. Now we're the ones that have to prosecute it. We better get it together. That is not the glasses you want to be looking through when you're trying to do a neutral, fair, and independent investigation into a crime. But that is exactly the investigation that was done in this case. Exactly. There is a fine line between suspicious and enough circumstantial evidence to convict somebody. The amount of suspicious things that they give you does not make it substantial circumstantial evidence. It is the weight of the circumstantial evidence or the pieces of circumstantial evidence that you find beyond a reasonable doubt that you then analyze. Not every single thing that they throw up to make him look bad or guilty. Example, in the closing argument by the state, all we hear is this statement was made, he should be home with his family and kids and not creeping around in the middle of the night. And I heard creeping around in the middle of the night at least 5 or 6 times. Folks, I established with the supervisor from the first restaurant, he owned his own business. This is what he did for a living. The hours that he made the payphone call are the hours that he worked, and he was working that night. He has to go to these restaurant franchises he has contracts with and do the work after they close. So he's not out creeping around. He's not out at a time he would not ordinarily be out. He is out when he is always out doing his work. Now, in terms of, I'm going to kind of start from the back and move forward. And I'm going to tell you straight up, I am not going to go through every piece of evidence with you. And the reason I'm not is because I am confident in the jury that I selected. And I am confident that you've listened and seen and heard what you've heard. And I'm confident that if one person missed something, when you're deliberating, the other person will remember. And maybe somebody else remember, yeah, she's right, that's what it was. And I also know that if you're in conflict about what a piece of evidence was, you have the absolute right to give the bailiff a note and come out and see that again. So I'm not going to try to supplant myself into your seats. That's not my job. The solicitor talked for a very long time. And the bulk of that talk was creeping around at night, this poor young girl being overwhelmed by an older guy, 40. He was 38 at the time. It was a consensual relationship. But the way that she's all this is not evidence. The only evidence is what was entered into evidence. She can talk for an hour and 20 minutes as to what her theory is, and she can say it over and over and over again, hoping that if she says it enough, you'll just buy the entire theory and whitewash the rest and go with it. That's not the way this works. If it was, I'd talk for 2 hours. Well, the judge wouldn't let me. I'd talk for an hour and 29 minutes, okay? And all I would do is hammer and hammer and hammer my theory on the case. I'm not going to do that. I'm going to point out to you the pieces of evidence that I think you seriously need to concern in order to acquit my client. The reason they tried so, and they've tried everything, the reason they tried so hard to establish that there were video cameras at Sidney Moore's residence before he bought video cameras, and let me stop there quickly, he went and got them on the 21st because what was going on in the media, people were coming up to his windows. Citizens on the Find Heather Elvis page were coming on his property, scaring his children in an attempt, in good faith, I would submit, to search. But nonetheless, there were many threats made. And on the 21st, he bought video equipment. This was a last-minute thought on their part. Well, what if we could say he had video surveillance before this happened and then took it down? Then the implication is, I can argue to them, that would have been the $1 million picture, but he got rid of them. You need to find that Sidney Moore had video surveillance footage at his house prior to December 18th, beyond a reasonable doubt. That's one of those circumstances. I submit to you that you can't find that based on what we've got here. And it's the little things you have to look at. One, the officer took 39 photographs. He was voluntarily led into the house to look around. He never took a picture of the video cameras. But 2.5 years later, he comes in this courtroom and tells you, I saw them. I remember seeing them. If he saw them, he would have took a picture of them. He also tells you he didn't take the picture of the inside one because he didn't want to be overly aggressive. Does that sound to you like officers 2 days in to investigating a potential kidnapping and missing woman? No. It doesn't add up and it doesn't make sense. If he wanted a photograph of a video camera there, he would have taken that photograph. If he wanted a video or a photograph of the video somewhere behind, stuck together, behind these trees, he felt like he'd done enough and he didn't want to wear out his welcome. Come on. All you got to do is step back 3 feet and take another picture. And if he says, well, these branches are in the way, you still could see through there. But guess what else? Just walk back up and take a picture straight up behind the trees, or walk over here and take a picture. That's just baloney. It's baloney. He didn't even make a report about it. He says, well, I told one of the other officers. He has no idea if there's any report that he ever told that officer of that. That doesn't make sense. You cannot, in good conscience, use that. Jacob Melton talked about these cameras. I'm not disparaging Jacob Melton because I was 17 one time. But he was smoking a lot of marijuana in 2013. So the times he's over there, the times he's not, you know, the first time they talked to him, they didn't ask him anything about video cameras. The first time that issue came up was June 1st, 2016. 19 days before we picked the jury, they got back with him, said, you remember video cameras there? Well, yeah. Well, guess what? He still lives around there. They still live there, and there's video, or the house is still there, and the video cameras are still there, and they've been there for the last 2.5 years. So sure, he's seen them. He's not saying he saw them before. That's what they were trying to get at. The best he could come up with was between Thanksgiving and Christmas. And then he knows when they took the family trip for those weeks, and they were gone from, well, you remember. If you need to know, you can come back and look at it. But up till December 11th. And then I asked him, well, between Thanksgiving and Christmas, and I don't even know if it's January or February, Jacob, or any time in the last 2.5 years you're talking about. But if I stick with that, could it have been the 21st, 22nd, the 23rd, or the 25th? Yeah, it could have been. Well, that's after the 18th. Now, when we talk about, and as I told you, I'm not going to tell you and go through every single piece of evidence with you because I trust you. And if you need to know something, you can come out and look at it again. He went to Walmart. He purchased a pregnancy test. He called Tammy, and the evidence said, I love you. I want to be with you. First, he didn't tell the cops. That's what he said. First, he didn't tell the cops. He called her. But let me tell you what investigators should not do in an investigation. And I don't even know, but it's probably in a protocol manual, is have the same two suspects, especially husband and wife, in the same room for an interrogation. And if you do split them up, they're still at the same station. The other one's probably out in the hall sitting on the couch or a chair. Because if you had nothing to do with the kidnapping, then why are you going to feel so bad about saying I didn't call her from a payphone when you didn't do anything wrong, and then your wife's not going to know that you called Heather that night? Okay? Those are the kind of things that you need to look at when you look at if you believe that piece of circumstantial evidence beyond a reasonable doubt. Because he didn't come truthful about that, which he did after they confronted him within 30 or 40 seconds. But that's what you have to look at. You have to take it all into consideration. The rest of the phone calls, and let's say that he called her and told her what Heather told Bree, he said, for sake of argument. Bree Worrellman told you that she believed, and she seemed like a very straight-up lady, that they definitely cared about each other. There was something there. Not one witness from the first three ladies from Tilt to Kilt all the way through have ever given you any piece of evidence that Sydney Moore was ever in any way mean or untoward to Heather, but anything but caring. He brought her favorite Starbucks coffee to work. So why do we assume, for sake of argument, if he did say that, it wasn't genuine? Maybe he did want to leave his wife and be with her, especially after just having a 3.5-week vacation with his wife. Maybe he came to that conclusion. Let me tell you the other thing Jacob Melton said. And it threw me for a minute because I had what he said before. I said, Tammy Moore, you said, had an iPhone 4 and an iPhone 5. Sydney had a flip phone and a Samsung. Right, I did say that. That I know. He traveled around with Sydney. He went to work with him. Did stuff like that. First he said no. I'm like, wait a minute. So I'm going to get in. Well, you said, the only thing I was mistaken, then he said yes, was Tammy Moore did not have an iPhone 4 and an iPhone 5. She had an iPhone 5. So Sydney had, and it doesn't matter whose name the phone's in. We're all in families. We're on family plans, and people use, daughter use your phone, this one, you use that one. My point is, when Ms. Livesay says that Sydney, lurking around, Sydney drove all the way down there. She's calling his phone. He doesn't pick up. He does pick up. 4-minute conversation. You have to ask yourself, does the evidence beyond a reasonable doubt support that that's Sydney or that's that phone? Because I had just picked up on the phone thing with Jacob. The phone that they're talking about is the iPhone, not a flip phone, not a Samsung. So when we get past here, the payphone, here's another issue. You have to ask yourselves this one too. If Sydney doesn't have that phone and Tammy has that phone, maybe that's the reason he's using a payphone. He did other things like this. You know, there was texting early November, and we're going to get to that in just a minute, but you're looking for a payphone. There are not many around. So then you finally see one across the street, so you pull over, stop your car there, and you walk through the parking lot. You don't have to pull all the way up to use a payphone. But the point is, one reason that you could use a payphone is because you don't have the cell phone. That's reasonable, and that's reasonable doubt. But the most important thing about this is that everything else that happens after this involves these calls, the iPhone in the black truck. Who is dealing with the iPhone and wants to see Heather Elvis? Ask yourselves this. If you want to believe that Sydney Moore kidnapped Heather Elvis because he thought she might be pregnant, then you have to believe that I've been sitting next to the devil himself this whole trial. The state started talking about Heather as an easy target, as if it was a serial killer. It's inconsistent with the relationship she built before. That she's sleeping in a car, she's not a vagrant, but she's a person who moves around, whatever that word was, and you know, the perfect target, okay? Somebody does not, particularly with a wife maybe they don't want to be with, commit a serious felony offense at age 38, just decide to do that because of that. Let me tell you how these cases generally happen. Serious felony offenses are more likely than not, they come from seeing red. They come from a passion. And I don't mean a good passion, but a rage and a passion. Sydney displayed that at no time. Nobody has testified or shown any time where in his life he has been an angry or passionate or mean person, in general or towards Heather. On the other hand, the other piece of evidence I want to point out in all this are the text messages from November 2nd through November 5th. And that is not a long list. I think it's only 2 pages long. And I urge you, somebody here, to remember to pull that out. Because that's vital. And you need to see that to make a proper decision. Because the messages during that time period are between the iPhone and Heather Elvis's phone. The messages, if you read them, are clearly not between Heather Elvis and Sydney Moore. They are between Heather Elvis and Tammy Moore. You ready to meet the missus? I've been having Sydney followed. Heather asked, when is Sydney getting his phone back? So obviously, when he made the payphone, maybe the phone's been taken from him. I don't know, maybe he's not even allowed to have a cell phone at this point. And then in the same stuff, there are texts where she's making it appear as if she is Sydney. And this is all in the same conversations. You need to look at it. Because my point to you is that is vital. Because that is a point in time where it's undisputed, if you look at it, that Tammy Moore is on the iPhone with Heather Elvis and even pretending to be Sydney Moore. Why do I say that's important? Because this night on December 18th, he doesn't have a cell phone, he has to use a payphone. Then all the other stuff that they say lures her to Peachtree Landing is coming from the iPhone. Now, they made a big point about how dark it is at Peachtree Landing. Fair enough. But the point is, you put Heather Elvis down there under those conditions and how dark and desolate where you can't see anything. You also don't see who's driving the truck. Whether Heather Elvis talked to her, had some drinks at Longbeard's and figured Tammy was making enough sense and sounding somewhat reasonable and we need to talk this out. If you are pregnant, I want to help you with it. You know, lured her in that way. Let's meet at the landing. We can figure all this stuff out. Sydney's an asshole. He's been with you and he's been with me. And that got her down there. Or whatever got her down there. If she was planned to meet Tammy Moore down there, or if Tammy Moore pulled up, and obviously you can't see who's in the truck till you get in the truck. And the truck takes off. Now, I spent a lot of time with the video expert, and a lot of that was because I don't believe that stuff. I don't. And I tried to make that clear to you. He said it's based on his experience. He didn't look at 14,000 cars. That was an audit. He looked at 11, only one other of which was the same type vehicle, same. But notwithstanding, and remember the other guy they brought for a different purpose, and I picked up on that. This guy had more education and training than Mr. Fredericks. He worked for the FBI for 3 years. And I asked him about this stuff. He was very familiar with reverse projection. Anybody that does this work is familiar with it. It's been done, it's proven, and it's done. That is not the same as headlight spread pattern analysis. Basically, what Mr. Fredericks is telling you is that every vehicle, no two vehicles anywhere have the same headlight spread pattern analysis. Now you have to take his word on that, of him telling you, I take this headlight pattern, I put it over that one, and I look at it and I say, that's not a match. The judge allowed him to testify as an expert based on his experience. It is not based on science, nor is he a scientist. The other guy was, and he said, well, I've heard other forensic video analysts talk about it, but I don't know anything about it, you know. If it was something, he'd know about it. That guy would know about it. They have to go to the other side of the country, to Washington State, Spokane, to find Grant Fredericks, who will write them a report that says that. And then I talked to him, and I talked to him a little bit about the troubles he was embroiled with his credibility, and he defended it some. He said, yeah, that report was wrong, but I didn't do it, somebody put my name on it, and, you know, I didn't prove that he did anything wrong, but I proved that the U.S. Attorney's Office have made filings against him for false reports. He's got an answer for it. He's embroiled in some controversy with that. There's no wonder he's working on the East Coast now. No wonder. But if you believe that that was Sidney's truck, ask yourself who was driving the truck. If you believe that was the same F-150, ask yourself who was driving it. Who has motive to want to do something like this? Is it the person who has not shown any type of aggressive behavior or mean behavior to anybody, including Heather Elvis, other than bringing her Starbucks coffee and calling her and saying, "I still want to be with you"? Or is it the person that the first three witnesses and Bree Warman and other people testified, even after it was found out and stopped, continued to harass and threaten and would not let it go with Heather Elvis, even to the point of sending pornographic photos of her and her husband to Heather Elvis? That shows you a state of mind. That shows you something in your mind that will not go away. And those kind of things feed on themselves. And that anger feeds on itself. And it doesn't go away. And they tried to tell you during the trial, through I think Jacob or somebody, well, Sidney's the only person that drives that truck. We're all in families. We're all in families. Don't buy that for a second. If Tammy Moore wants to drive the F-150, Tammy Moore is driving the F-150. See, this case is about common sense. I am not a prosecutor, and I am not prosecuting Tammy Moore. I am defending Sidney Moore. Tammy Moore is charged with kidnapping. Tammy Moore's trial is coming up. It will be in this courtroom. There will be 12 other people to decide what happens. I'm merely asking you to use your common sense and you come up with the more likely scenario. Because if you don't, somebody's getting convicted for something they didn't do. And I'm sure that my client doesn't like every single thing that I'm saying. But I have to go where the facts lead me. I'm sure he doesn't want to think that about his wife. I'm not sure if it's crossed his mind. But it is his wife, or more importantly, the mother of his 3 children. I'm not even sure if I want to sit next to him when I go back over there. But I tell you this, I'm going to say what I have to say as I see it. Ladies and gentlemen, this system is as strong as you are. I've tried cases in this courtroom, many, from murder cases to everything in between, all the way down. And you know, most times I try those cases, there is nobody sitting out here. I've tried so many cases in here with a person that doesn't even have a family member sitting behind them. My point being, you have a lot of people in here. You have nobody to reward or punish. Your judgment cannot be based upon passion or prejudice. It has to be based on solely what's been presented and how you find it. And when the judge calls you the finders of fact, I always like to point this out because that's always caught me a little weird. It doesn't mean you have to solve the case. You find what happened. You find the facts that you can find and determine whether you can convict Sidney Moore beyond a reasonable doubt. That's what it means. In this case, there are reporters, television cameras. I've got trials I wish got that kind of attention. But you can't be swayed by that either. You all took a solemn vow as citizens of this country to do the right thing. As far as we're concerned, and the work that we're all doing in here, you might as well put a wall up between those seats right there, because it's about us, and it's about you. I have done everything I can do in a case where they can throw all kinds of suspicion out. And if you don't think it's hard to defend a case like that, think again. When they spend 2.5 years focused on one person to the exclusion of everything else that could have happened, then I've got to try to look at everything else that could have happened because nobody else ever did. But I submit to you, based on everything I've just told you, Sidney Moore did not kidnap Heather Ellis. Sidney Moore is not a kidnapper. And if you want to do justice in this case, based on how our system works, which is the only protection we have if we wind up sitting at that table, is this, and you, or whoever's sitting there at the time, if you want to do the right thing, and you want this system available for anybody that needs it, then you will find him not guilty. Because this case has not been proven beyond a reasonable doubt. Thank you very much.